Please, Lordship. Lordship, I beg to mention hearing item number 12 for respondent number 1. Lordship, here my
Hearing
senior
item
counsel.
number
12. 1, 2. 12.
1, 2. Yeah.
Here the senior counsel is in bereavement, Lordship. If the matter can come up after 2 weeks.
The request of the learned counsel appearing on behalf of the appellant
For respondent number 1.
for the respondent number 1 matters contingent on with this after 2 weeks.
Lordship, similar prayer for item 14 as well.
Who is the senior counsel?
B.N. Sharma, Lordship.
Who is the
B.N.
senior?
Sharma.
Where is he? His name is not there in item number 15.
14, Lordship.
Item number 14. Okay.
Lordship. Much obliged, Lordship.
May I please, Your Lordship? My Lord, I beg to mention hearing item number 10. My Lord, I'm mentioning on behalf of Wisdomami. My Lord, his wife is not feeling well. That is why he could not come to court today. So kindly list the matter after 2 weeks, my Lord.
What is the matter about?
Worship, this criminal revision petition has been filed against conviction, my lord. So, Worship, my case is here that the conviction was solely based on the plea of guilt, my lord. So I have filed this criminal revision petition.
Guilty being pleaded.
Yes, my lord, he pleaded guilty, my lord. And he has been inside the prison since the day he was arrested, that is 2016, my lord.
You have objection?
Worship, I was informed just this morning that his wife is not well, so
Yes.
Person is inside, what to do? If a person has pleaded guilty without being told what are the consequences, then there is no guilt pleading. There's one judgment being delivered by me and Justice.
yes, my lord, I have the judgment, my lord. It's 2022 to JLT, my lord, which is reported, my lord.
So, my Lord, then that matter will come next week, my Lord. Next week, at least 1 week, my Lord.
If a person is inside the jail for 1 day, isn't it bad?
Yes, my Lord, but since
Does
the,
your conscience permit that one person should remain 1 more day? You are PP.
yes, my Lord.
You being the PP, you should be therefore knowing it. You have to appear, therefore, you have to be an unbiased prosecutor.
But my Lord, this case I'm not handling. my Lord.
So we will say that the PP is not present. Tomorrow,
Not, my Lord, then Friday,
not
let,
Friday.
let me go through the brief. Because the
through the
brief is with
Go through the
council, my
brief.
Lord.
There's no problem. Go through the brief. You have a brief, have a look at the brief today itself. We'll have it tomorrow.
Worship.
Because my conscience does not permit, if a person has been not told the effect or the consequences of pleading guilty, then in that case, I think it is the case by which it has to be set off, set aside.
Thursday, my Lord. Thursday. Thursday. Day after tomorrow.
Why?
Thursday.
No, tomorrow.
My Lord, I have a similar brief for item number 13, my Lord. I mentioned on behalf of Wisdomami.
This is partner before me.
Yeah.
I don't remember a partner. Item number 13, which matter? With the pain. This partner before me. Yes, madam, this is partner before me.
Yes, your lordship.
Item number 13,
Yes, your lordship.
how? I don't remember. And if it has been partnered for all this while, how is it possible? District after winter vacation. That, where is the partner? This was the case to be dismissed. Didn't it?
Your lordship.
This was the case which I was supposed to dismiss. But you got an opportunity on 10-12 because I was leaving on 11-12. Don't you think so? This matter has been wrongly shown in the list, causeless to be partnered. Mr. So-and-so appearing on behalf of the
Wisdomami.
state.
Your
Request for
lordship, may I please?
accommodation.
Your lordship, on the last occasion, the leading counsel for the petitioner, he has completed the submission in this matter, and it was the respondent number 2. The counsel for the respondent number 2, he was supposed to make a submission.
I remember,
Yes, your lordship.
that was the case which I was supposed to dismiss. This is a case of 307.
No, your lordship, 138, and I act, your lordship.
138.
Yes, your lordship. In this case, the petitioner, he was sentenced to imprisonment of 2 years.
They've been received.
with a fine of rupees 15 lakhs.
Submission of the Iman is that thereby convicting the appellant is complaining that much as for the purpose of arriving at the conclusion that was. Oh, yes, yes, yes. And what business you have? You are the state.
Yes.
These are negotiable instruments matter. State have no business out there. Does it?
Yes, Lordship. The
I have been instructed by my friend to mention the matter. Who is the mommy?
Mr. Vijimomi never appeared in this matter. Mr. Sentianga appeared and Nisuki Sisi appeared. This is a case which I remember that there was no finding that there was a debt.
yes,
Isn't it?
Lordship. Yes, yes.
Without there being a finding as regards the debt, there could not have been a punishment under 138. That is the simple case. One Miss Nisuki AI was appearing. Government has no business. Are you going, is the government now providing legal aid?
No.
Then we have no business. Mr. Long Kumar was there. Unless Mr. V.G. Mummy or the PPs are holding the briefs of private respondents.
Mm.
And help it.
Mm.
Should we observe that?
Mm.
Okay. Don't ask for adjournment for this matter.
Much obliged then.
Yes.
Please, Lordship, I beg to mention hearing item 11 on behalf of Council for Kalan and Jamir. On the joint prayer, if this matter can be listed on 12th of May,
When?
12th of May. Lordship.
12th of May.
Yes, Lordship.
Any good
Lordship,
day? 12th of May is some specialty.
Lordship, the councils in both the cases, the leading counsel in both cases are from outside outstation lawyers, Lordship. That is why, Lordship. Lordship, I would
Okay.
suggest
The
if
councils appearing on behalf of both the parties submits that as the leading counsels who will be representing the parties are both outstation counsels. The matter be fixed for hearing on 12th of May 2025.
Lordship, there's this 12th is the
You want it on a holiday? Madam?
Lordship, 24th of April, Lordship, if Lordship.
24th of April.
24, there is some difficulty on the side of the Council for Appeal.
24 difficulty.
Yes, Lordship.
Okay, Leo.
Then
The
Lordship,
councils appearing on behalf of both the parties are not ready to do the matter when the matter is called up. So taking into account the above, let this matter be listed after 6 months.
No, Lordship.
Next.
Thanks.
May it please your lordship. I beg to mention in respect of unlisted criminal revision, your lordship. I've been instructed by my seniors worldwide to humbly pray before this honorable court. Listed today at 2 p.m.
2 p.m. I'm not sitting. I have difficulty. What is this? Bail? Criminal revision.
Criminal revision,
Should
lordship,
have it tomorrow.
tomorrow.
Tomorrow. Okay, let us call item.
Of my children.
For motion, item number 1.
Yes, what is this contempt?
Lordship.
Contempt for what?
Lordship, this court is directed in WBC 282 of 2024 by order dated 14/11/2024, Lordship, to consider the case of the petitioner for appointment on compassionate ground, Lordship, within the period of 4 weeks. But Lordship, despite the lapse of more than 3 months, it has not been considered, Lordship.
This was on 19th.
Lordship.
19th, 4 months, March ends. You informed about
Lordship,
this.
4 weeks, Lordship. To consider my case within a period of 4 weeks, Lordship.
4 weeks.
Lordship. Page 11, Lordship. Annexure A.
Issue notice returnable on May 2025. Steps be taken upon the respondent numbers 1, 2, and 3 by way of registered as well as usual. The case of the petitioner herein is that there is a direction issued by this court on 14/11/2024 in WPC number 282/2024, whereby this court directed the respondents to consider the claim of the petitioner for being appointed under the compassionate scheme within a period of 4 weeks from the date of receipt of the certified copy of the order. The counsel appearing on behalf of the petitioner refers to Annexure B series to show that all these documents, that the certified copy of the order dated 14/11/2024 was received on 19/11/2024 by the respondent on 19/11/2024 by the respondent number 1 and 2 and on 13/12/2024 by the respondent number 3. He therefore submits that as within the period of 4 weeks, no steps have been taken for consideration of the case of the petitioner, a case of initiating contempt proceedings against the respondents have been made out. The respondents are directed to bring on record their stand by filing the affidavit on or before the next date.
Obliged, Lordship.
For motion, item number 2.
May I please, Lordship, my lord, this instant petition is filed for seeking extension to comply the Honorable Court Direction Order dated 22/8/2024 passed in WPC number 202 of 2023. My lord, by order dated 22/8/2023, 2 months has been given to the state respondent to consider the petitioner case, my lord. And my lord, the petitioner case is under consideration and it is before the finance department. So due to following the lengthy process of consideration, it takes time, my lord. So, my lord, another 6 months may be granted, my lord.
Has the petitioner retired?
Lordship. My apologies, my lord.
You don't have a file?
Lordship, my apologies, my
He
lord.
has not given you a copy?
He did give me a
No,
copy.
I apologize, sir.
I have my
You
sincere
want
apologies.
to
I have
appear in
misplaced.
a more digital manner.
I have misplaced my copy, my lord. My humble apologies, my lord. However, my lord,
We do one thing, earlier time was sought for on
Yes, my lord.
4/4/2025. Have you received a copy of this application?
Yes, my lord. Yes,
Do
my
you
lord.
have any
So,
objection in
yes, my lord.
extending?
Yes, my lord. 6 months, they're praying for 6 months extension time, my lord. So I have objection to that, my lord. Since this matter pertains to regularization, my lord.
Your lordship, may kindly see page number 13, annexure P.
Has the petitioner retired?
No, still serving. Yeah, the petitioner has completed 30 years. So that
On-
is why.
He has already completed 34 years.
Yes, my lord,
Yes, yes.
24 years.
45
Now
years.
tomorrow you will retire him.
Yes.
And then he has no other source, you won't get any pension, nothing, because you are delaying it. This order was passed as far back as on 22/8/2024.
Yes.
That means he is almost coming to be 35 years.
Your
Don't
lordship,
retire him.
yes, my lord.
No, don't retire him. Give an undertaking that the petitioner will continue to work.
No, my lord, your lordship, may kindly see page number 13.
Yes.
Page number 13, Annex P.
Hmm.
May I read, my lord?
Yes.
The relevant portion of it. In pursuance of the above mentioned subject, the Honorable Court, High Court Kohima bench by
At
order
the earliest and
dated 20 years.
preferably at the completion
As a
of the
writ
process for
petition
regularization at the earliest and preferably
within
process
2 months.
undergoes following stages in Iman and so has been forwarded to demand on 19 and day. In fact, madam, yesterday I was going through one judgment. I think it's a very relevant judgment for all cases in times of days. That is a judgment by yes. Can you take note of 2021-17 SCC 750? Now, what is it? What is the direction given by the Supreme Court? Because this is similar scheme.
Yes, madam.
So there the scheme was the scheme for regularization of those who have completed 10 years or more of continuous service within minimum 240 days in each year, as on so and so approved by the Supreme Court, subject to certain modifications.
Yes.
Now, the Supreme Court said in this judgment
Yes, madam.
that the regularization has to date back to the date on which he completes the 10 years, not on the date on which he retires. These are very important issues. Here you see what he's saying. It was brought to the notice of this court that so and so learned counsel for the university and 890 postage were created coterminous with the service of their daily wages who have been absorbed. He made a valiant impress upon this court that no further posts have been created and therefore the remaining daily wages cannot be regularized. By way of implementation of this court in so and so at so and so. By this order similarly situated in Iman, the division bench have taken note of this. There is an error in the judgment of the High Court which warrants intervention. Eligible area will be in accordance with the right of the area. It has been held that the regulation as a one-time measure and so, this court approved the scheme of so, the remand creation of union is taken. So when are you completing? You can't ask for 6 months. And more particularly nowadays too, you have come up with another scheme. You have added, the government has added more pressure to itself.
Yes.
Earlier, you were not able to handle the pressure with those person who were work charge and casual.
Yeah.
Now you have now brought in fixed wage as well as contingency.
Yes.
Then
That one is different.
you
case.
don't have the machinery for that, then now you are delaying it. You can't delay this.
No, my lord, here we are, the state is not intentionally delaying the petitioner case. We are under consideration. We are considering his case. But due to the process is taking time, my lord. See that his file is before the finance clearance. Day after it will go up to MRC. Day after it will go to cabinet for approval. So it takes time, my lord.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the respondent state, on behalf of the applicants, and Ms. So-and-so appearing on behalf of the respondent opposite party, oblique the writ petitioner. This is an application filed by the applicants who are the respondents in WPC number 202/2023, whereby the said applicants are seeking a further period of 6 months for completing for complying with the order passed by this court dated 22/8/2024, passed in WPC number 202/2023. Fusto. Ms. So appearing on behalf of the respondent, a petitioner, submits that already 8 months have passed, how much? 8 months have already passed by. And the respondents are seeking a further 6 months, which would result in regularization of the petitioner after he retires, in as much as he had already completed 34 years of service as on the date on which the judgment was pronounced by this court. This court have duly considered the learned counsel, the submission of the learned counsel appearing on behalf of the applicants, who submits that certain process are required to be completed, and without the same being done, it would not be possible to do so, and this would require some time. First, this court have further taken note of the office memorandum dated 17/3/2025, 15, wherein it is being categorically stipulated that a person who completes 30 years of service as on the day, along with a scale of pay, is entitled for regularization.
Yes.
First, taking into account the above, it is the opinion of this court that the petitioners oblique the opposite party hearings right to regularization had accrued on the date on which the opposite party oblique petitioner had completed 30 years of service along with the scale of pay. First, therefore, it is taking in that view of the matter, this court grants the applicants a further period of 6 months,
6 months.
6 months to further period of 6 months, that is on or before, to complete the said regularization process on or before 6 months. Let's see, Monday. What is the today's date? 7th. Huh? Today is 7th.
Yes, ma'am.
Yes, my lord.
7.
Worship.
30 of September.
By
Worship,
by
since
8th of
taking-
September.
Taking into consideration that the petitioner will be retiring soon, my lord, if a shorter period.
I am going
may
to
be-
take care of that.
Yes,
By on or before 6th of October 2025. First, it is further directed that as the petitioner is entitled to be regularized, the regularization shall date back to the date on which the petitioner had completed 30 years of service. That is on, give the data,
yes, ma'am. I will give that.
because he worked from 9/5, he worked from 9/5/1990.
Yes, ma'am.
Okay,
Yes,
so
ma'am.
just give when it will be the 30
Yes,
years.
ma'am, that I'll check.
With effect from so and so. So the petitioners, further, the respondent shall, on the basis thereof, shall provide the benefits to the petitioner.
Much
Much
obliged.
obliged.
We got a better order, madam.
For admission, item number 3.
May I please, Your Lordship,
Yes.
I'm for the sole respondent here.
Huh?
I'm sole respondent,
You are the sole respondent.
yes.
Very good. What is he challenging? Mr. Iralu, what are you challenging?
Yes, Lordship,
Your Lordship, only this morning, just a few minutes ago,
yes.
I received a counter filed by the respondent.
But
Counter for what?
on earlier occasion, I've sought permission to.
No, what are you challenging? Mr. Iralu, what are you challenging?
The impugned order is.
Quash and set aside the decision taken on Iman passed by the Gauhati of Kohima village.
It is by the Gangura's union.
Ah,
A union has passed an order show motu. At
So
page
you want
16
time,
Page 16.
Mr. Yulalu, you want time?
Yes, let it come up after 2 weeks. Because what they are saying, I want to know. Yes. Maybe
What is the,
written, not
what is the
written.
order passed by the, yeah, what is 110/2024,
Page 16, Your Lordship.
page 16?
Yeah, this is the translative page. Now, Kohima village GB's union,
Since the decision passed by the Kohima Village Gauhati Court on Iman has not been followed on Iman, the Kohima Village women went to the disputed land between so and after seeing the development exit past the area will remove the houses constructed before so and if it is not done, so will pay 4 lakhs to so and the land and house will belong to them. Okay. Now, why are you challenging this?
because Your Lordship, in 2004, GB's Kohima village has passed an order in favor of the present respondent. I prefer an appeal against that order under Rule 31. Now, the court has decided to go for a de novo trial. And in the meantime, the sole respondent, as plaintiff, sought the permission of the court to file a plaint. The trial court has granted that one. After filing the plaint, I also have filed my written statement. Now, thereafter, the court has issued summons to the parties, but the party fails to turn up. So for non-prosecution, that was dismissed.
Suit, his
That-
suit is dismissed.
Yes,
Okay, then,
that's then dismissed, and the sole respondent has not taken any steps for
Restoration.
vacation of that one, or restoration. Then ultimately. in
so
two-
now therefore you are saying,
Yes.
once it has gone to de novo trial,
Yes,
the decision, and you have challenged this,
yes,
and the appellate, the power is exercised under 32, 31.
31,
So under 31, the power is being exercised,
yes.
and has the order been set aside?
That has not been set aside.
So if it is not set
But-
aside, then what happens?
Uh,
Because 31 does not say about setting aside.
It does not say set in the side, but there is only 2 conditions here under 31. One is if the decision appears to be just, it can be affirmed.
Affirm.
Or if not, then the only option is to go for a de novo trial. Then in that respect, now the appellant is by me, appellant is me. So more or less, partly my appeal has been allowed to go for a de novo trial.
No, de novo trial will be yours. You are the suit, you have to,
No,
the trial will
I'm
be
the
yours.
respondent.
No, you can't be the respondent. You are aggrieved by that order, you have filed an appeal.
Yes. But the
So
original,
that appeal is
original complainant is the respondent.
understood, but that your appeal gets converted into a suit then.
Only after filing the plaint.
So you are
That
to file the
was-
plaint.
After
He has
filing-
filed a plaint.
Yes. He filed the plaint, it was made, converted into a suit, 1 of 2008.
But without setting aside this order. This order, because what happens if I understand correctly, 31 gives you a right to appeal.
Yes,
Once you file an appeal, the deputy commissioner would either confirm it on the principle of just and all decision,
yes,
or he may go for a de novo trial.
yes.
The de novo trial will be not where he becomes the plaintiff. The appellant becomes the plaintiff.
No, he is the original complainant. The original complainant should remain the plaintiff.
Where is it?
There is no, under that rules, there's no specific provisions
No,
provided.
because then the issue is to be decided. The issue will be you being aggrieved by an or judgment passed by order or some order passed by the GB.
But your lordship, that may not be regular, but then in the present case, the respondent sought permission from the court, trial court, to file a claim. The trial court has granted the one. Now for non-prosecution, that's then dismissed. That is totally a different picture, your lordship. And they have not taken steps for restoration of that suit.
But the GB decision remains.
No, your lordship. Because once the court decided to go for de novo trial, then it goes, it clubs with that order. And
Let us see
dismissal
the order
is
by
goes
which,
with-
let us see that order by which the trial ADC received by so and so against the decision of the Imam on so and so fixing so applicant to take steps over here. Order here, so is stated, stayed until further orders. This 2004 order has been stayed until further orders. Received the appeal so and so, counsel was so and so. The appeal and presence so and then we have heard both the party that claimed and non claimed. Present heard both the party that claimed on the claim and it can be time. We know when the interest of both the party, therefore this parties are to submit issues on the day. We speak of fixed up, so and so started with the Now the case is before whom?
Before assistant to DC, civil judge, General Division.
You filed a plaint.
Yes, Lordship. Lordship, regardless of whether I have filed my plaint or not, I'm not the appellant in the present matter, in that matter.
You are
And
not there.
the matter was dismissed for non-prosecution of both the parties. Even the petitioner here, they did not pursue the matter. And the matter was, therefore, it was not decided on marriage, Lordship.
Your lordship, in that case, order 9 will
Your
come to
Lordship,
play. Rule 9, order 9. Rule 3 and 12. When no party appears.
Order
It
9
can be-
rule, order 9 rule 4,
12,
3.
read with 3.
Order 9 rule 3 will come into picture when order 9 rule 2 comes. Means a date being fixed for hearing.
No, 3. Non-appearance.
So they can,
Of
in
parties.
terms with order 9 rule 4, he can file a fresh suit.
That whether that will be a question.
No, he
But
can fail.
he has to restore the dismissal of his.
No, it is not required to be restored, taking into account order 9 rule 8. It is not a dismissal in terms with order 9 rule 8.
It'll be in terms of rule 3.
It will
Read
be
with
under
rule
rule 4.
12.
If it
Read
is
with
under
rule
rule
12.
4, he can very well file a suit.
Your lordship, let him file a suit, that's okay. But then.
But
because
why will he file a
We
suit?
can contest
No, why will he file a suit? He has a decision in his favor.
if he wants to.
No,
If
why
he
will he
wants to,
file?
let him file a
You need
suit.
to file a suit. You have to file a
No,
suit. He
Your
doesn't
Lordship,
want to file a
he-
suit.
he-
I respect
His
it.
suit was dismissed. So why should I file a suit, Your lordship?
No, he should not at the first file a suit itself. The suit ought to have been filed by you. There's already a decision of the GP. The decision has not been altered.
Your Lordship, this is a very peculiar case. And in fact, the rules, if we continue with this, then Rule 31 will be turned into this or that. And
No,
then
but
the
order,
person will
but
face
rule
a lot of-
31, if a person, because when a decision is given by the, either way, it may be a case of where a Dubashi court or Gaubura has given a particular decision out there, and an appeal lies to under 31, the decision remains always, the decision remains unless it is set aside.
Your Lordship, my appeal has been allowed
No,
by way of,
where's the, where's
by way
the,
of going by a de novo trial.
no, the
Because
court
I
may
bring for
go
that
for a
one.
de novo trial, means instead of taking up the entire thing, he will become, the court will direct them, okay, we will decide the entire aspect by which asking both sides. Your appeal, the copy of your appeal becomes your plaint.
No, Your Lordship.
Because you
that-
are challenging an order. This order is already there in his favor. Because otherwise, if we go that he has to again file a suit, then it will have a, because what happens to that order unless it is set aside? Yes, if it is set aside, the court
But
may very
by
well
virtue
set
of
aside.
because de novo trial means it has clubbed with the earlier order passed by the village council. And
Show me any
it
judgment,
clubbed with the appeal. So
Mr. Irelu.
once the suit is dismissed, then that goes.
No,
And therefore,
the
the
court may,
opportunity of the respondent is to file a restoration application.
no,
at that
restoration
point
is
in
not
time.
required. Taking into order what order has been passed, restoration is not required. Because of the fact that kindly see the CPC. See, you have a CPC, anybody?
No, Your Lordship.
Have a
Your Lordship,
thing?
give us a little more time. Let me go through.
Tomorrow? Finish it up
not-
tomorrow?
Not tomorrow, Your Lordship.
Tomorrow?
Okay with them.
Because tomorrow I have programs.
Ask him, ask him.
Thursday?
He's a very good lawyer. Ask him to appear.
Your Lordship,
You don't need to do it. You have already started the suit. I see your name from 2004.
yes.
Yes.
Yes,
So we are, this is a 21 years as of now
yes.
going
Now,
on.
Your Lordship, that I get the point is,
List the matter tomorrow
in-
for further
Your
hearing.
Lordship,
We'll hear it tomorrow.
Thursday, Your Lordship.
Tomorrow.
No, Thursday.
Tomorrow we'll see. Let him argue. You have a difficulty. If he has difficulty, if Mr. Iralu, if in the circumstance I am going to dismiss your case, I will give a chance for you to argue on Thursday. Let him start.
Your Lordship, that would not be fair. Means
I'm giving you a better chance for him to also argue. If I'm giving
Your
you
Lordship,
that
since I have filed a
opportunity.
counter, and since Your Lordship is now.
First of all, the
inclined to
question of counter, that
dismiss of my
Mr. Iralo, in the
Let me put-
proceedings under 115 or 227, the question of counter does not arise.
Yes.
There is no concept of a counter.
That
He
is-
has filed a counter or not, and we are not bothered. I'm not going to
Yes.
look into it. We
That's
are
right, Your
going to
Lordship.
decide a very important aspect as to whether it becomes a suit or not. Let him argue tomorrow, and thereafter let him serve some judgment. And if I am going, I feel
Your
that
Lordship,
no,
He
Mr.
has a
Iralu.
fixed matter, Your Lordship, that is.
No problem. Other courts won't be sitting much. Today, other courts are rising at 11:30. I will be only sitting here. Don't worry. So 11:30, so other courts won't be sitting.
Working with you, Your Lordship.
We'll take it up tomorrow.
All right, Your Lordship.
And if I want to, I will be dismissing his case. Then I'm fixing it again on Thursday for you to argue.
Under the rules,
Huh?
under the rules.
For admission, item number 4.
Yes. What is this? What is this contempt? Contempt for
Yes, Your
what?
Lordship. Your Lordship, I have instruction to withdraw this contempt petition, Your Lordship. Your Lordship, I have the instruction to withdraw this contempt petition.
Why?
Your Lordship, from the leading counsel, I'm not appearing in this case, Your Lordship.
No, I'm not concerned. Can you withdraw contempt?
Yes, Your Lordship.
Very good. Show me the law. You can't withdraw contempt. Withdrawing a contempt is because the moment you place it before us, then we are to take it with we and him is the business. Isn't it? You can't withdraw. Now, what is the contempt? We dismiss your contempt. Interim order, you are filing an interim order, but this interim order has not been extended by me. Remember? I think your senior is going to withdraw it tomorrow. Isn't it? Yes. Ms. So-and-so appearing on behalf of the petitioner submits that taking into account that the interim order passed by this court dated 12/8/2024 have further not been extended, nothing further remains in the instant proceedings, and further submits that the contempt proceedings have become infructuous. Taking into account the above, the instant contempt proceedings stand strong.
For orders, item number 5.
Lord, I pray for time.
Why,
I-
what? What is the direction given?
Last occasion, I was to file the.
Mr. Imchin, why are you asking for time? You have your counterpart, she will ask for time.
No, I'm representing the defaulting department
Another
that is in
extension of
Gauhati.
compliance. Oh, there is already an extension, nothing has happened. Is this the state of affairs? This is for what?
This for money,
Payment of money.
payment of money.
What is the direction given? Salary,
No, it is for
salary.
error, salary error. Yeah.
So you have not paid him.
We will pay, but it is under process. This is what I have learned.
Now what is
Because,
this?
It has to go to the finance, from finance. there is
But
business,
it is on the face of it, it is contemptuous. But this is the first time it has come. Oh no, many times. My goodness. You have not filed your reply also. Chalo, who are those people? We will do one thing, discontinue their appearance to the council and ask them to be personally present in the court.
May I please, my lord?
No,
Lordship,
no, why haven't you filed your reply?
no, your lordship,
No, we are not concerned to that effect. Why haven't you filed your reply?
lordship,
We give you an opportunity to file your reply
Yes.
only on the basis that, okay, the representation can be done effective by so and so.
yes,
Here, the notice was issued on such a long time back. What is wrong?
lordship, I just have to make one submission, lordship.
Please.
I'm representing respondent number 1. The chief secretary. This order is relates to the payment of the area salary of 2 months. Because a notification was issued. So it was a payment of area salary of 2 months, your lordship. Now, area salary, your lordship, my office have hardly got anything to do, your lordship.
So why haven't you filed your reply to that effect?
Lordship, yes. I have not filed to that effect.
Okay,
lordship.
we impose 10,000 cost to everybody. How much is your area salary?
The area salary is for 2 months, your lordship.
How much it would be? 80,000?
Your lordship, I'm not aware of the.
So for 8 persons, 80,000. 7 persons,
lordship.
10,000 each cost.
Your lordship, this
No, no.
relates to all the affairs.
No, we are not concerned because why haven't you filed your reply? This is not done.
Lordship will file, allow me.
This
to
is
file a
absolutely
witness
hurting the majesty of the court. This can't happen like this.
Lordship, allow me week's time.
Okay, file it by Friday. Mr. Mohanchins and Mr. So-and-so submits that one further opportunity be given to the respondents to bring on record their stand. Pusto. list the matter again on Friday.
Population.
Motion, Mr.
For orders, item number 6.
Mr. Lordship, Lordship, this court has directed the respondent to dispose of the repetitions, representation filed by the petitioner. Then, Your Lordship, on 22nd. On 22nd of February 2024, Your Lordship, we have replied to the representation filed by the petitioner.
No,
Your Lordship.
no, but now, madam, in view of the
Yes,
notification
yes,
of 5/3/2025, we are going to consider.
cover, Your Lordship, but despite of that, Your Lordship, the petitioner filed the contempt.
Obviously,
Yes,
because
so-
at that point of time, there was a direction given.
Yes, yes. So Your Lordship,
Now
this is
you,
on this one.
your submission would be that in view of the office memorandum dated 5/3/2025,
Yes,
they would be given the,
Yes.
yeah, so steps would be taken.
yes, yes.
And
okay.
as such, I close the conference.
Yes, Lordship.
Ms. So-and-so appearing on behalf of the
So.
learned additional advocate general, no?
Yes, Lordship.
Appearing on behalf of the respondent submits that although the order passed by this court dated 2011, although the submits that the representation so submitted by the petitioner have been duly considered and rejected, isn't it?
Yes, Lordship.
Rejected. And the petitioner was informed about the same by a communication dated 22nd of February 2024. Full stop. The copy of the said communication dated 22nd of February 2024 was handed over, was placed before this court, which is kept on record and marked with the letter X. Full stop. The learned counsel, the learned additional advocate general further submitted that in the meantime, the government of or Nagaland have already come up with an office memorandum bearing number AR-3/GEN-64/2001 dated 5th of March 2025, whereby all work charge and casual employees in all departments whose names have been duly verified by the district level verification committee and registered in PIMS, receiving fixed pay shall be granted scale of pay as per the revision of pay, 2015 with effect from 1/4/2025. Taking into account the relevance of the said office memorandum dated 5/3/2025, the relevant portion of the said office memorandum is reproduced herein below. Ei consultante. Eikin lage, ei naam kita lage, ei tu na lage, copy tu na lage. Reproduced herein below. First, taking into account Mr. So-and-so, the learned advocate general, additional advocate general submitted that taking into account the said office memorandum, the case of the petitioner would be taken up in terms with the said office memorandum and process. The learned counsel appearing on behalf of the petitioner therefore submits that in view of the office memorandum dated 5/3/2025, he would further not insist to proceed with the said contempt proceedings. With the above, in view of the above submissions, this court closes the instant contempt proceedings with an observation that the petitioner's case now be considered in terms with the office memorandum dated 5/3/2025.
Much good.
Much obliged.
For orders, item number 7.
Dispose date. No? Yes.
This, your lordship.
Oh, criminal case.
Yes, your lordship. Your lordship, your respondent number 2 is still awaited, your lordship.
What?
Service upon respondent number 2 is still awaited, your lordship.
Read response number 2.
Lordship, the ABISA, your lordship.
What do you want?
Lordship, if the matter can come after 2 weeks.
Bail.
No, your lordship. Criminal petition, your
What are you asking for?
for quashing of the AFI, your lordship.
There's no stay.
No say, your lordship.
quashing of the FIR.
Yes, Your Lordship.
Criminal petition, you are challenging what case?
Lordship. G47.
Complaint.
Yes,
It's a
Your
complaint case.
Yes, Your Lordship.
It is under 304 IPC, Lordship.
Okay, no, he's asking for complaint,
What?
quashing of a complaint case.
No, FIR, Lordship.
Complaint as well as the
Then
proceeding. Your
how can a trial court records be called for?
Lordship, as the FIR as well as the criminal proceedings, Your Lordship, filed before.
There cannot be a trial court record.
Uh,
Has the charge sheet been submitted?
Yes, Your Lordship.
The scan copy of the copy of the trial record was called for scan copy only.
Okay. Now the trial is proceeding.
Yes, Your Lordship, there is no stay, Your Lordship.
Whatever, your case under, let us see the FIR, why you are challenging. If it was the FIR, then charge sheet has been given.
Yes, Your Lordship.
Have you challenged the charge sheet?
Lordship, FIR as well as the criminal complaint, Your Lordship.
Huh?
FIR as well as the criminal complaint, Your Lordship.
No, what you are challenging, let us see. Person says the FIR and the criminal proceedings so and so, you are challenging. The criminal proceedings you are challenging, huh?
Yes, Your Lordship.
34. What is the FIR so?
Lordship, page 18, Your Lordship.
I have the honor to report that around a month, namely so and so, came and voluntarily surrendered himself to the police, reported that he accidentally shot one woman of the yard during hunting and also reported that she had taken to district hospital by her relative. In this connection, proceeding to the hospital and found that the injured person was brought dead. He is identified as so and so. Therefore, requesting your esteemed authority to look into the matter. Okay, then. So this is the FIR.
Yes, Your Lordship.
Then how do you ask for quashing?
Lordship,
Is it possible?
This is heinous and very serious offense. So
Obviously,
yes, Lordship.
it cannot be. Jesus said, it will be the trial court will look into it. How can you ask for quashing of this? The person died.
yes, sir.
Whether you will be convicted under 304 or whatever, maybe somebody or you had some, you may take whatever defense you had. That is a defense. The question of quashing doesn't arise. Who are you?
Lordship, I'm for respondent.
You are a dead person
I'm the younger brother.
of the dead person.
Yes, Lordship.
You are opposing.
No, Lordship.
You want both of you to hear that he made a mistake. But how can we quash?
Lordship.
No. No case.
Lordship, if the matter can come out on Thursday, Your Lordship.
Oh, what? 5 minutes.
Not make it. Yes, my lord's knows very well. It not make any difference actually.
It's 5 minutes only.
Lordship, yeah, I'm not here in this matter, Your Lordship. My senior
So we dismiss it on the ground that none
Lordship is on
appears.
court one, Your Lordship.
Huh?
He's in court one, Your Lordship. If the matter
Don't make that submission because at 11:30 court number 1 have already risen.
Lordship, if
I
the
was
matter-
also supposed to join the other 2 judges,
Lordship.
which I said I am not. I'll be joining at 1 o'clock only.
Lordship, if the matter can be taken up.
You are there,
is that matter,
Mr. Longchamp. In this case,
No, Your Lordship.
then
If the matter can come up after the list matter, Your Lordship.
when?
After the listed items, Your Lordship.
No, we are finishing it now. No case. Jan Singh and all these things won't come in. Hello, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. K. Angami. Appears on behalf of the respondent.
One Lordship.
Number 1, Mr. So-and-so appears for the respondent number 2.
Respondent.
2, 3.
Three,
Three,
Lordship.
Your Lordship.
There's no 3.
Yes,
There's
Your
2.
Lordship.
Another person has been made a party.
Lordship.
Yes, Your Lordship. We filed
Huh?
memo of parties, Your Lordship.
Okay, he appears for respondent number 3. First, you appear for 1 and 2. 1 and 2. 1 and 2 and he appears for respondent number 3. First, this is an application filed by invoking the inherent jurisdiction of this court under section 528. Read with section 438 of the Bharatiya Nagarik Suraksha Sanhita 2023. Praying for quashing and setting aside the FIR dated 13/12/2021 on the basis of a compromise deed entered into by and between the petitioner and the respondent number 3. Full stop. At this stage, it is relevant to take note of. Full stop. This court finds it very pertinent to take note of the contents of the FIR, wherein it is seen that the petitioner herein, wherein it has been alleged that the petitioner herein had accidentally shot one woman of Hupang village during hunting, and the person and the person who was shot succumbed to the injuries and expired. On the basis of a compromise entered into between the petitioner as well as the brother of the deceased, dated 26/10/2024. The present proceedings have been filed for quashing of the FIR as well as the further proceedings in connection thereto. In the opinion of this court, the offense which have been alleged is an offense under Section 304 IPC, read with Section 25(1)(b)(a) of the Arms Act. And the offense being serious in nature, the question of quashing of the said offense does not arise. Considering the above, the instant petition, this court finds no merit in the instant petition, for which the petition stands dismissed.
For hearing, item number 8.
Mr. Longshal, just wait for some time. I'll take it as the last item today. Let me finish up the other matters.
For hearing, item number 13.
Yes, where is the other side? Oh, where is the impugn order?
Page number 64, Extra 14.
Yes, Mr. Longkumar.
Yes, my lord.
I heard this matter earlier.
Yes, my lord.
How do you take care of this? Is it a case, we can't remand it,
Yes.
unlike a civil proceedings.
Mhm.
But without the finding being given by the trial court
Yes.
that there was a debt,
Yes.
they cannot come to that, because without that finding, it is not possible.
Yes. Only the issue is that he has issued a check, and then the check was found because of the insufficient fund. And then he was also the part of the transaction. He was
But
also a
to
shareholder.
make out an offense, where is that impugn order?
Lordship, in page number 64.
Yes, page 63. For the complaining is allowed, accordingly, I hold the accused so and so have committed offense. A check is the and under the admitted the accused has issued the check in favor of Iman. The complainant is therefore entitled to the benefit of the check, and that she obtained is so and so. In this case, the rebuttable presumption under Iman operates in favor. It is also proved that checks were dishonored on presentation of so and so, and the accused has failed to respond to the said notice, and the content has. That's it. No way out. No. This is an application filed under section 401, read with section 397 and 482 of the Code of Criminal Procedure 1973 for quashing, for setting aside the order dated 13/4/2022 and the subsequent order dated and the consequential order dated 15/12/2022 passed by the learned Chief Judicial Magistrate Kohima, Nagaland in Negotiable Instruments Case number 1/2022. Full stop. I've heard Ms. So-and-so, the learned counsel appearing on behalf of the appeal petitioner, and Mr. So-and-so appearing on behalf of the respondent number 1. You are appearing?
Yes, my lord.
Yes, So-and-so appears on behalf of the respondent state, for the government state of Nagaland. For respondent number 1, are we on respondent number 2? Full stop. The issue involved in the instant proceeding is the challenge to the order dated 13/4/2022 by way of the instant proceeding is on a specific to the finding, the specific case of the petitioner herein in respect to the challenge to the order dated 13/4/2022 impugned in the instant proceedings is that the learned trial court, learned court of the Chief Judicial Magistrate Kohima, that is the learned trial court, had passed the impugned order dated 13/4/2022 without arriving at the finding that that the check was issued in for discharge of an enforceable debt. Ms. So-and-so, the learned counsel appearing on behalf of the appellant, has referred to the judgment of the Supreme Court in the case of Indus Airways Private Limited versus Magnum Aviation Private Limited, reported in 2014, 12 SCC 539. Full stop. This court had duly perused the impugned order dated 13/4/2022, wherein the learned trial court have duly taken note of the whereby the learned trial court, merely on the basis that a check was issued by the petitioner in favor of the complainant, and the check having been dishonored on presentation, and no steps were taken in spite of service of the notice, have convicted the petitioner and have passed the impugned order convicting the petitioner under section 138 of the Negotiable Instruments Act 1881, along with a direction to pay a fine of rupees 15,000, which 15 lakhs, which shall be deposited by the petitioner within 30 days before the court. Full stop. This court finds it very pertinent to observe that in the entire impugned order dated 13/4/2022, there is not a single whisper that the check in question was issued in discharge of an enforceable debt. In this regard, this court finds it relevant to take note of the judgment placed by the learned counsel appearing on behalf of the petitioner, that is Indus Airways Private Limited Supra, wherein the Supreme Court observed at paragraph number 8 and 9 as hereinunder. Also, from above quoted paragraphs, it would be therefore seen that the Supreme Court categorically observed that to attract an offense under section 138, there has to be a legally enforceable debt or other liability. In that view of the matter, as there is no finding to the effect that the check which was issued by the petitioner to the complainant was in respect to a legally enforceable debt or other liability, the impugned judgment and judgment order dated 13/4/2022 cannot be further sustained in law. Accordingly, the impugned judgment and order dated 13/4/2022 therefore sets aside and quashed. This court further finds it relevant to take note of that the subsequent order dated 15/12/2022, being an order passed in consequence to the order dated 13/4/2022, the said order dated 15/12/2022 therefore also cannot survive in absence of the order dated 13/4/2022. In that view of the matter, the instant revision application stands allowed. NCR which had been placed before this court be returned to the courts below.
Your pleasure, Lordship.
At last, part had finished. No, actually, on 11th, I had to go, some family urgency. Otherwise, it should have been finished on that.
For hearing, item number 15 and 16.
Yes, Mr. Singh. Some lawyer was mentioning this matter. Then I saw that, oh, Mr. Seki's name is there. Then how can I do so? Yes, tell me.
Lord,
What are you challenging? FAO. FAO is my, the principal seat is my bread and butter. Tell me.
Your Lord, here, your Lordship, here, in this case, before a related trial court, they had a plaintiff. The respondents here are a plaintiff. They want land compensation. So if it is a case where land compensation is permissible, then that's a different issue. This is to do with a remote area where road connectivity is very much required. In fact, it is also an important route, but it is not a national highway.
Wait, what are you challenging?
Here I'm challenging the proceeding before the learned court below. One is challenging the injunction order. The other is challenging the entire proceeding itself on a.
How many petitions are there?
2, Your Lordship.
One is an FAO.
Yes, Your Lordship.
FAO is the injunction order.
Yes, Your Lordship.
Let us see the injunction order.
Well,
Where is it?
Your Lordship.
Page.
Your Lordship, the injunction order is at page 246 to 247.
It's
Then
an
a subsequent
injunction
orders
order?
are also there, Your Lordship.
Wait.
Annexure 22.
Oh, civil revision. We want to take the FAO.
Lordship.
FAO, both are this FAO. Oh, we have without civil revision. Me, so and so appellant against have been filed challenging the order where temporary injunction was granted to the appellant plaintiff in respect to the property or the remuneration and has been put the appeal is admitted, fixed for hearing and before the petition.
Your Lordship, the main order starts from 256. Annexure 24.
No, revision, wait, these are two revision or FAO?
Your Lordship.
Okay, now what is the order passed? 11/6.
Yes, 11/7, Your Lordship.
11/6 or 7?
The 11/6 is also there, Your Lordship, but the main order under challenge is the last
Page-
injunction order 11/7, page 256, Your Lordship.
256.
Your Lordship.
Okay, I have given my anxious consent that so and so order 39. So we'll have to sum. What is the temporary injunction given?
Not to construct the road, Your Lordship.
Huh?
Not to construct the road.
Not to?
Not to construct the ongoing construction of the road, Your Lordship.
It and then the same is allowed only on the portion of the payments there during the road. So only in respect to the plaintiff's land.
Yes, Your Lordship. But however, Your Lordship, as far as the construction is concerned, my Lord, to construct in that manner, it's actually not convenient for the contractor. Yes,
No, no, did you acquire the land?
Your Lordship, the villages, the plaintiffs are not only landowners. 90% of the landowners, since it is a project under the CRIF, where until and unless it is a national highway, there is no compensation. So, Your Lordship,
Who is making the road? Who are you?
my client, the contractor.
How can you make somebody's road on somebody's land?
Now, Your Lordship, here, this is a project under the CRIF.
What is that CIF?
The CRIF is the Central Road Infrastructure Fund. I have annexed the documents also, Your Lordship. There is no compensation for the land, Your Lordship. So only when the land is freely given, because of limitation of funds as such, unless it is a national highway or a link road, what road is that?
So, Mr. Seki, tell
Yes,
me
Your
one
Lordship.
thing.
My Lord.
So, in that area, Article 300A does not apply, I suppose.
No, not necessarily, Your Lordship. But
Does it apply or not? Article 300A.
here is a case where my Lord will understand this, the technicality of the issue, where village area, the lands within the village areas, the administration is, my Lord, under the Article 371A. It is the village authority. We have the Village Councils Act also. We have the rules for the administration of justice and police in Nagaland also. So this matter first has to be adjudicated at the village level. Then the appellate authority that is with the administration as far as the rules for the administration of justice and police in Nagaland is concerned, my Lord. So, my Lord, the first point is that without exhausting those possibilities, it has come before the district judge directly. That is one of the contention raised.
He has filed a suit.
Yes, Your Lordship.
So is a suit barred? Is
So,
it
my
barred?
Lord, not necessarily barred if you go by the general laws, Your Lordship. But what I'm saying is, this is a village land and within the village administration. So until and unless a village had given a particular decision when they approached, or the administration has given a decision to that effect, whether they could have directly approached the civil court. That is one issue. The other issue is, Your Lordship, if at all, since this is a project under the Central Road Infrastructure Project, Your Lordship, where there is no provision for land compensation, and what the people require is actually a good road. And it's not that the entire area of their land is being damaged or taken away. It's just a small portion that is required for expansion of the existing road. Nobody has
Why are
objected.
you not, you are the contractor.
Yes, Your Lordship.
What about the village council?
The village council is also here, Your Lordship. The contractor as well as the village council. They
Why is the
together-
village council not settling with the petitioner?
No, they were someone, but they did not.
Yes,
come.
yes, Mr. Council, why are you not settling amongst yourselves?
Lordship, if I may.
Please.
Lordship, though this is the CRF project, there was no consent from my end as a landowner. The NOC, which was required, was purely given by the village council without my consent. I had approached the district administration as well, wherein the village council had clearly stated to me, I have the petitions also annexed, Your Lordship. The village councils had requested me to kindly give them some time so they can speak to the contractors or the concerned parties so that compensation can be worked out. And I had opposed in every situation that compensation should be granted since I am the landowner. The land is rightfully mine. It belonged to my ancestors. I had purchased it. So you have to,
Mr. Counsel, you have a good case.
Yes,
There's no
Lordship.
problem with that.
Lordship,
But the fact remains there is one thing as regards, one is the law.
Lordship,
Very well, you have a good law.
Lordship,
Law is in your side.
Lordship,
So there's no quarrel with that. The appeal is required to be dismissed. Revision will also be dismissed. There's no quarrel. But the fact remains is another aspect,
Lordship,
which is justice. Now here, the entire people out here
Lordship,
require this particular portion of it.
Lordship,
If it can be negotiated and done somewhere, it's a different thing.
Lordship,
That is the only thing which I am saying.
Lordship,
Because there are certain areas, if some portion, other areas are being given, this area is not being given. Yes, in other areas, the people out there is have given and they have paid some compensation and you are not being deprived, that can't happen. But in all the villages out there have already given there some portion of it. And if it does not harm you, why don't you have because you can't treat, you means all things can be treated in an other manner.
Lordship,
Now tomorrow in the case that, because one thing I am sure, the moment you give, tomorrow national highway, if it is made, you are not going to get any compensation.
Lordship.
That is another thing. So you don't have a case, but if you try to negotiate with it, you don't have a case.
Your Lordship,
What is right?
if this matter may kindly be referred to the High Court Legal Service Authority to see whether there can be any negotiation between the parties, because
Are you ready?
at the end of the day, as far as the contractor is concerned,
Contractor cannot help it.
no, my lord,
Why
what
you
I'm
are
trying to
making-
say is,
No, you are
I'm
concerned-
representing
You are the
the-
contractor, you are more concerned because you are after all going to get money.
Your Lordship,
Share some money from yours to him. You
Your
are not
Lordship,
going to do that.
it is
You
going to
have a
open a
case.
Pandora box, Your Lordship.
that is the issue, Your Honor.
No, my
I-
lord here, my lord here, my lord, may
I
kindly
understand.
distinguish this. Kindly allow me to distinguish this, Your Lordship.
There's
Since I'm
nothing-
representing,
Mr. My principal seat, my bread and butter is this, as well as land acquisition. Right, left and center, I only deal with that. So the question is like this, if you give the land, if tomorrow it becomes a national highway or state highway, you are not going to get a single penny.
Lordship,
Telling you.
Lordship,
If you don't give the land, yeah, villagers may not like, which is a different society altogether. But on the other hand, if the contractor he wants to make money by making a construction, he needs to do something also, think about it to the villagers also.
my lord, may kindly allow me to distinguish it in two lines, Your Lordship. Number one, since
I give you 3 lines.
my lord, yes, since I'm representing both the contractor as well as the village council, as far as the contractor is concerned, don't do it, then I have no issue with it. From the contractor's point of view, it's just a small stretch of land which is disturbing the entire construction. So from the
So you are-
contractor's point of view,
Mr.
Yes, Your
Sethi,
Lordship.
you are already getting good money for the others. Spare some and give it to him.
Your Lordship, that would be opening a Pandora box. Now, from the village council's point of view, everybody has contributed. They have refused to be part of the meeting also despite several invitations, Your
No, I
Lordship.
am not therefore asking you to make the payment like that. You know how to do it. You are a very clever person.
Your Lordship.
So settle it out with him. Settle it out with him. Then only things will happen.
So, my lord, if my lord
Your
may
profit
kindly-
margin may
yes.
come down a bit. Your profit margin may come down, but the overall, think about that also for the village.
Your Lordship,
If
even
you,
if,
if you don't want to lose, but he has to lose, where is the balance?
Your Lordship, things can never be done in a way of understanding because it will always be flared up. So, my lord, we have also tried from our end, but by learning,
Otherwise,
there's a
there's no
very
case.
adamant line.
Is the suit stayed?
yes, Lordship,
No, we will vacate the state, let the suit proceed.
Lordship,
No, Your Lordship, my lord,
Let the suit proceed. Injunction, let it remain. Injunction rightly passed. Notice.
Your Lordship, I may be allowed to argue from point to point to show whether personal interest will prevail
No.
over public interest here, Your Lordship.
No. That has already been negated by the 7 judges. Earlier 5 judges were there. Now recent judgment of the Supreme Court has already said no. That is the big issue which came up in one of the matters where there was a judgment and where there was a judgment of Justice Julia. Remember? Where he said that, in fact, what submission you were making was what was held in Chinaya by Justice Krishnaya about Article 38C. But this is no longer the law. You cannot take away like this.
Lordship. Now, my Lord, there is another point which, if my Lord is
You are,
inclined to dismiss, Your
no,
Lordship.
first of all, are you doing it for free? Are you doing the construction for free?
No,
If
Your
you are
Lordship.
not doing the construction for free, then why should he lose?
Lordship. Then, my Lord, in that case, we must also appreciate the prevalence of the Village Council Act of 1978. This Honorable Court also must appreciate the prevalence of the rules for the administration of justice and police in Nagaland. So in that view of the matter, there is a special consideration also to be given in this case where whether they have exhausted.
Question is, where is the bar? Is there an implied or a bar? Because you
No.
therefore have to say that section 9 kicks in. You see, section 9 of the CPC says that if you are in a case where you are asking for the court in respect to all civil matters, the civil court will have jurisdiction unless it is expressly or impliedly barred. Now show me where it is.
No bar, Your Lordship.
Then-
But then we have to understand the given society also, Your Lordship. Now the given society is such that when the entire society wants and one or two is a spoil sport, whether that is also to be given a consideration by the Honorable Court, because today, if at all the suit is dismissed, or for that matter,
Mr. Counsel, kindly
Madam.
appreciate,
Madam.
Article 300A is a constitutional right.
my lord, my lord,
It is it is given earlier, which was a fundamental right, has been removed, but then also it is a constitutional right, and it is now akin to human right. You are taking away his human right without compensation. How do you help him? And are the court or we not the state? And in view of
Madam.
Article 51A, not bound that to enforce the provisions of the or to follow the rule of law. What is wrong with that order? Order is perfectly fine.
my lord, my lord.
So how much we dismiss civil matters we should dismiss with cost. You must have spent a huge amount of money in engaging you. So 70,000 cost on each matter. Dismissing with cost.
Your Lordship,
Don't you think that on one hand, you want to take over his land?
we can just keep his
You
land,
want
Your
to
Lordship.
take over his land without money. He is compelled to file a suit. And then because of your appeal, he has been compelled to engage him. And he has taken a huge fees also. See,
Your Lordship, both
We are
parties are
without
spending money
compensation.
when it comes to litigation. My Lord is fully aware of that. So even if the issue is to be dismissed, the prevalence of the Village Council Act and the rules for the administration, if it is not to be appreciated, at least the cost, my Lord, will be kind enough not to impose that because it will not only reflect,
he has come to the civil court.
Your Lordship, so
And
my
civil
client
court-
is also spending there also, here also, my
Civil
Lord.
court, see section 35. It's a question of imposition of cost.
Oh, my Lord, if it is a frivolous appeal or revision, Your Lordship,
Please.
that's a different
You're
issue.
taking away.
But, Your Lordship,
And who has filed the appeal? Has the village council come and filed appeal?
yes, they are also a party to the appeal, Your Lordship.
Party to that appeal.
To the appeal
Respondent,
here.
they are the defendants.
Yes, yes.
They are not the appellants here.
They are also appellants, Your Lordship.
Yeah.
Yes, Your Lordship.
No. No. Who is the village council appellant? Chairman, village council is the appellant.
Yes, Your Lordship.
Proprietor infra. Chairman, they are village council, they are the appellants. They can't do that. So we should dismiss with cost.
No, my lord,
70
my
and
sincere,
70,
no, your lordship,
40,000.
my lord, your lordship,
That will be highly appreciated, Lordship.
at least my little friend should not be happy because, my lord, now, even if there be no implied bar, your lordship, there is a village council act. There is a
So
rules,
what?
your lordship, so,
No, what? Unless you show me there is an implied bar.
no, my lord.
Maybe there
Respectfully,
might
your
be
lordship.
there might not be an express bar, but there has been implied bar. Read the recent judgment of Justice Partiwala on
Where's
these
the
aspects which have been taken. Mr. Seki, best option is withdraw all these things. Or I dismiss it. Dismiss though, I'll do it. There's no quarrel with that. But once it is dismissed, you cannot negotiate. Finish.
Going by the understanding of your lordship,
Think about it. I'm
Then-
coming in 5 minutes.
your lordship. Bless your lordship.
Correct. Okay. Ma,
Let me see, Lordship.
Yes.
Your Lordship, I sincerely appreciate your Lordship's
The thing is this, if
option, yes, your Lordship.
I dismiss your appeal or the revision, then in that regard, I will give a finding. Once I
Yes.
give a finding, your option of negotiation is zero.
Your Lordship.
That is what is the problem. Otherwise, you are always at liberty to accept, take the judgment.
Then, my
And the
Lord,
Supreme Court has been
Yes, Your
very clear, in all judgments.
my Lord, seven judges
Cannot take away
judgment,
somebody's rights.
the seven judges bench judgment, which my Lord has mentioned, can I please take note of it?
Huh?
Because the seven judges bench judgment, which my Lord was mentioning
Yes,
about the.
You see on Article 338C, that's the judgment, where earlier the law was this. That was a case which came up from Bombay.
My Lord.
That whether public interest
Yes.
is supreme, so that a person who have even a private interest over the lands can be taken away.
My Lord.
The judgments which were delivered by the 5 judges in 1978-79, because at that point of time you are to think about a particular system where India was in a very developing state.
My Lord.
So it was therefore required therefore 31C was removed, which was the right of fundamental right to property was removed, all these things
My
were
Lord.
there.
Yes.
Then the matter came to, I think it's not a year judge, 7 judge, it's a 9 judge maybe.
Oh.
So the question came up before the Supreme Court, and it is now been written by, that judgment has been authored by Justice D.Y. Chandrachud, wherein he held that no, you cannot say that because of Article 38C, see this section article. Here you see 38, not C, 38. State to secure a social order for the promotion of the welfare of the people. The state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all the institutions. The state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities near not only amongst the individuals but also amongst the groups of so and so. And then you see this here, 39C. Certain principles of policy to be followed by the state. The state shall in particular direct its policy towards securing that the operation of economic system does not in concentration of wealth and means of production to the common detriment. So that was the interpretation which was given then. And these have changed. Because in Bombay, what was happening, some prime lands were taken away by operation. So this matter went to here and then it went to this council because of the judgment in Chennai, it went to this judgment.
My Lord.
It's a very important judgment.
My Lord.
There are, the judgment was given by 5 judges, one opinion by Justice D.Y. Chandrachud. Then one opinion was by Justice Nagaratna, who supported it. And the third
previous
judgment
judgment.
was by Justice Dhulia,
Okay.
who
Lordship.
supported the earlier view, Justice
Lord.
Chira, of Justice Krishna. So what to do?
And my Lord, may kindly allow me to withdraw
Very well.
your Lordship.
Mr. J. Saki, the learned counsel, appearing on behalf of the appellate, in FAO number 1/2000 appellants in FAO number 1/2024, as well as the petitioner in civil revision petition number 15/2024, submits that as the issue involved in the suit involved in the suit and issue involved in the suit pertains to certain lands being required by the village council for the purpose of construction of the road, which is for the betterment of the public. Endeavors shall be made to have a negotiation with the respondents, with the plaintiff, who is the respondent herein. And as such, would not like to press both the proceedings before this court. Taking into account the above, the instant proceeding stands closed on withdrawal. Full stop. Interim orders, if any, stands vacated. Full stop. Is there a stay?
Lordship, there was a stay, Lordship. Mr. Lordship.
Full stop. Further to that, the interim stands vacated. Full stop. In view of the vacation and withdrawal of the instant proceedings, both the proceedings and the vacation of the interim orders, the parties who are duly represented shall appear before the learned trial court on 2nd of May 2025. 2nd of May 2025 for further proceedings of the suit. It is, however, observed that the tendency of the suit shall not bar the parties to arrive at a negotiated settlement.
My lord, Lordship. Lordship.
Records, if any, be returned by the courts, by the registry and forthwith, so that the records were called, huh?
Yes, Lordship.
Will be records, the records so of civil suit number so and so be returned forthwith to the court below, so that and ensuring that the records are available before the learned court on 2nd of May as fixed here by this court.
Lordship.
For hearing, item number 8 and 9.
Reading finished.
WBC 241 of 2016.
Now, Mr. Longshaw, tell me, what is the finding arrived at as regard his health condition at the time of death, prior to the death?
What I'm saying is, my lord, the fact finding inquiry have not taken into consideration of even the FIR. FIR against the disease. The person who here are claiming to have lodged the FIR was not examined.
Complainant was there.
Complainant is there, one Vinod Lama.
No, here it is mentioned out there in the, that these people were called, he had come. And you see here, first paragraph itself, appeared before, also appeared during the inquiry, during summons, though summons was not, the undersigned proceeded to earn so and so, his steps were also being taken. No, I'm not on that, Mr. Longshaw. You
My
see,
lord,
There are two ways by which there has already been a commission of inquiry being done as per the Commission of Inquiry Act. Okay. So the question will rely on, there are two aspects. One is, if you want to challenge the inquiry report, you have to challenge it independently. Because this is an inquiry report that has to be challenged in a separate manner. That is one. The second aspect, which I thought about it, is if the person at that point of time was in fit condition or medically proper, because always when a person is taken in custody, a medical report is being taken. That is the law.
It was not produced.
No, no.
for the inquiry.
Whether when he was there, his
Yes.
medical report would have been taken. Because the moment a person is arrested, first he is taken to the doctor. And when the doctor also gives an assignment, yes, he is good, is in good health, and as such, he's arrested and put in the lockup. This is how the manner it is. So at that point of time, thereupon, this person hanged in the ventilator, na?
That is what you
No,
raised.
yes, in the ventilator. So under such circumstances, when a person is in police custody and an incident happens, then by applying the doctrine of res espa loquitur, which is one of the very fundamental doctrines, this court can take it as a constitutional thought and impose certain direction for payment of compensation.
That is second aspect of the matter.
Huh?
Second aspect of the matter.
That is the only
Yes.
aspect of the matter remains. At the end of the day, the question is of compensation in the proceedings of constitutional
Yes.
thought. It
Yes.
is, you are approaching this court and asking for a constitutional thought. Now, applying those principles of D.K. Basu and all, we can think that it is take it as a constitutional thought, because how can in the custody of a police, a person die?
Hello. The whole issue is that.
So the only thing is for payment of compensation. Whatever may be, there will be a question of payment of compensation. So as such, we are therefore to decide as to what should be the compensation to be payable, because there is already a constitutional thought. Now, you wanted, there are first aspect, you wanted a CBI investigation. For that, I have already had a commission of inquiry done.
My lord.
They have done it in this particular manner, whatever may be, you may not be satisfied, for which you may have to challenge the Commission of Inquiry report, because it is done under the Commission of Inquiry Act.
My lord.
You have to challenge in another aspect. But that may not further your basis. The only thing which can be given in these type of cases is a case by which holding it to be a constitutional thought, passing appropriate directions, and imposing compensation. You must have gone through one of my judgments which I delivered.
No.
Let me tell you fully. This was a case where an advocate, the issue happened like this. An advocate parked his car somewhere. When he parked his car, the traffic police who was there, he assaulted the advocate. Then the traffic police lodged an FIR. The advocate also lodged an FIR. The moment the advocate lodged an FIR, he was arrested. Arrest is okay. There's no quarrel with that, but he should not have been. But he was arrested. But what they did, they paraded him with handcuffs and took him to the CJM court in Gauhati. And then from there, again with handcuffs, have taken him to the police station. No, not the police station, but to the jail. Then later on, that advocate concerned was acquitted. Okay. Now the question is, the advocate filed the proceedings before the Assam Human Rights Commission that he requires compensation for illegal case against him and all.
Humiliation in happened.
The Assam Human Rights Commission dismissed it on the ground that the person who did it was not alive. Because the person, that inspector who did it, he was not alive, so nothing could be done, so it was dismissed. The matter came before me. I said that no, it is a question of a constitutional tort. And I imposed the state of Assam a compensation of rupees 5 lakhs. So you need to go through this, because there I discussed everything. So the question here at the end of the day, as you have till now not challenged the Commission of Inquiries Act,
No.
this, the question is as to when he was in custody, if anything happens, it was the responsibility of the state, the police officer. So therefore, it is the duty of this court shall take it as a constitutional tort and impose compensation. Applying those principles which have been held by D.K. Basu and all these things, how it is to be there, there might be thoughts or whatever may be. But at the end of the day, it is a question of compensation. What do you say?
My lord, I have to challenge the inquiry in that case.
If you want to challenge it, okay.
Yes.
If you want to challenge this, very well, you can very well challenge it.
My
But, I am not stopping you. But at the end, what I am saying, Mr. Loncha, once a inquiry report is given, you will challenge it, the court may hold it, okay, this is not done properly. Then a further investigation may be given. You may know what is the truth, what may have happened, what may not have happened, what may. But end of the day, it is the question of compensation on account of a constitutional tort. Whatever may be, that person who may have been responsible then may have retired, he may have died, all these things may have happened. That is another aspect of the matter. But here the state is equally responsible. Would it be in the interest of the person concerned to again challenge this inquiry and just to further lengthen the proceedings? Or would you only argue on the question of DS? He was in custody, which is proved from the inquiry report itself, and he died in custody, which is an unnatural death. If that be so, it is how could this thing remain out there? And as such, if it was remained, then appropriate directions can be passed by the court.
My lord, I'll leave it up to your lordship. Yes, I have understood you. The
Because
mind
I
of your
think
lordship.
if that is
Yes,
in that line, if we proceed,
yes,
it would be much more in the interest of your client also.
blind lord.
Because he wants a resolution to what has happened,
My lord,
a closure.
my lord.
A closure in a sense like tomorrow when this court imposes a constitutional, on the basis of constitutional tort, even gives you 1 rupee as a compensation,
My lord.
it is a vindication of what you have been
My lord.
fighting for,
Ultimately, that is.
isn't that?
Yes,
That the state was wrong in doing so, and this is what has happened.
my lord.
If you argue on that line, have a look at that. I will see my judgment on this aspect.
My lord.
That is why I put it as regards, this is a case where Justice Krishna was taking up the issue. First, it came up before Justice Krishna in one matter, where a person was put in what you call handcuffs. Then it was said that the handcuffs are known as irons in legal parlance. You can't put these people, confine them with irons. That matter, that was one of the very beautiful judgment. It is being referred in my case. Then there was what happened. One day, one of the persons concerned, some judge, he went to a particular place in a hospital in Gauhati. There he saw that these Tada detainees, This at that point of time, these other detainees were there. No? So what they were happy, they were cuffed with the irons on one hand and then tied to the beds. So then he wrote a letter to the Chief Justice of India. The Chief Justice of India took up as a suo motu PI and then decided, and there were various directions given that you can't do this. And if you can't do all these things, then in that case, in spite of those directions, you have put these people in handcuff, that advocate. Whether he was there or not, because even in the prison manuals, in my judgment, I say, the prison manuals have become old. These were made at the time of British era. Now things have changed, you cannot. So there, I therefore say that no, you have to pay an amount of 5 lakhs as the compensation for putting him this. Maybe it may be too less for that advocate, it's a different thing. But this 5 lakhs which was given is a vindication or a closure to that effect that he has been unjustly detained. Have a look at the judgment. I'll ask him to give it to you. You argue tomorrow or day after, whenever you feel like. Have a look at DK Basu and how you can do it. It's an interesting case. Huh? Day after.
Yes.
Okay.
Your Lordship, that case may also be produced to me. Your Lordship, that case may also be given to me because I also have to go through your taking into consideration the case of the petitioner. Of course, Your Lordship, I have regard to the case of the petitioner. However, Your Lordship, the facts of the case should also be taken into consideration. How he was arrested.
Yes, madam, I'm not getting you.
No, Your Lordship, let the order be given to me also so that.
Oh, yeah, sure.
Your
Sure.
Lordship.
No, you have a look.
Yes.
Therefore, I'm referring to the judgments of DK Basu. DK Basu, you can find it out. There are various judgments which are being happening, but my judgment which I have given was I'll just give it to you. Wait. You can even put it in life law and put my name and go for. If you put, we have live law. Have you seen live law?
That is
No.
next.
No, everybody has a live law nowadays. You don't need to. Just put my name out there, you get the judgment out there. Which just. Yes. Live law comes like this, my judgment. In live law, if you put my name out there, this judgment comes up. Because it is famous all over India because of this judgment. The lawyers were never given compensation like this. I'll give you the citation with.
Yes.
But I've given you WhatsApp, I've given the judgment. Take printouts too, give it to both of them. Then you look into those Sunil Batra and all these judgments, because here I referred to Sunil Batra extensively. You see, the words used by Krishna in the judgment, I have quoted it extensively this year. First, Justice Krishna's judgment was of Sulin Batra, where he observed that fetters, especially bar fetters, shall be shunned as violative of human dignity, both within and without prison. The indiscriminate resort to handcuffs when accused persons are taken to and from the court, an expedient of forcing irons on prison inmates were held to be illegal and should be stopped forthwith, save in small category of cases where an under trial has credible tendency of violence and escape. This is what I held out there to that effect, and there in Sunil Batra it was held handcuffing is a prima facie inhuman and therefore unreasonable, is over harsh and at the first flush arbitrary. So this is bad on that basis. But then I went into the question of being a constitutional thought, how a person can be granted a compensation. And more particularly in these paragraphs where I have referred to, I've referred to this Nilavati Behera. This is an important judgment. We will find the citation, everything here. Then my final year, now the question arises as to what should be the compensation that the respondent authorities should be directed to pay to the petitioner. There cannot be a straitjacket formula which would determine the amount of compensation that has to be paid. The compensation which is required to be paid is by applying the principles of strict liability. While awarding compensation, the court would have to take into consideration the loss or damage that might have been caused to the person who had been handcuffed to recompensate him, her for such damage. Apart from that, the court would also have to consider the imposition of compensation as a deterrent to the police officers who do not discharge their duties in proper manner and or violate the applicable law. The imposition of compensation should also be such that a concerned police officer should follow the applicable law in both letter and spirit, and are put on notice that non-following of applicable law would result in they being made liable to make payment of the monetary compensation to the arrestee. In normal circumstances, a direction is to be issued to the state to make payment of compensation, and the compensation so paid be recovered from the arresting officer who has put the handcuffs. But in the instant case, as the arresting officer had already expired, this court is of the opinion that such direction would not be proper. Accordingly, direction was put to the state. So therefore, the compensation has to be made on the basis. There are certain things you may think about. Have a look at the judgment. What are the parameters on which the compensation is to be done? Okay. List the matter on next day, Wednesday, for the hearing.
Your Lordship, if we can,
Wednesday?
Thursday, Your Lordship.
Thursday, I don't have time. So Friday, I'm there, and Sunday, and then I'm not here now.
Okay, then.
Let's have a hear her,
Okay.
how he develops his arguments. Don't worry, I'll give you time because this is a very important matter.
Yes, Your Lordship.
This matter cannot be disposed of like this because we need to concentrate on how, if a compensation is to be paid, what are the parameters to be looked into.
Yeah, that's
In this judgment, I looked into the parameters to the effect that how much that a person, an advocate, if he is paraded on with irons, what is the impact upon his clients, upon him? These are various important aspects to be looked into. In fact, while I was a lawyer, I did one case. It's a very important case. This was a child, he was studying in Assam Valley. You may have heard about this incident. He was class 11 or 11, I suppose. He used to play guitar. He got electrocuted. Then he died. Then the question happened, we filed a suit against the Assam Valley. I was a lawyer there. Filed a suit against Assam Valley, asking for passing appropriate special damages as well as general damages. Now, there are very important aspects which normally don't do. A general damage is given as a deterrent. Now, these constitutional thoughts are being given as a deterrent. Whereas special damage is given in respect to specific expense, or just for example, the loss which is all the for hospitalization, whatever may have happened, these are special damages for which you need to prove. But general damages, you don't prove it because you apply the principle of the res ispa locator. So the trial court dismissed it on the ground of some, what do you call, some technicalities. Matter came before the division, before the High Court. I was arguing it. It was shocked. The Assam means the school was trying to give a higher amount of compensation. They were agreeable. But my clients who were there, they were not, they said that if I get 1 rupee also is good. But it would be a vindication that the school from the next time has to have a teacher present when these students are playing electronic items. The court gave us 40 lakhs and means my client all donated the entire 40 lakhs to some institution. They didn't take any money. They donated everything. But this is the vindication which they had. So this is your, they have a closure. They were not concerned with the money, but it is the closure. It is, the judgment is by Justice Prasanto Deka. It's reported. The name is by Debosit Das and another versus Assam Valley. Because this needs to be further developed, because you need to look into those two judgments, which are Nilavati Behera and all. Then how, if you want special damages, what is to be given? General damages, this court will do it. And what are the parameters you need to argue? Means what is the loss which is being happened and all. Okay.
Whether his case will be covered within that, whether his case will be covered within that parameter of the laws given.
Yes. Okay.
Congratulations.